I'd like to call our meeting to order. Mayor Crouch is ill tonight, so I will open the meeting. First thing we'll do is a call to order, and then our roll call. Councilor Carlisle.
Present. Here.
Councilor Gordon.
Here.
And here. Board here. Councilor Pointer is here. We all stand for the pledge of allegiance.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, first thing we have is a public hearing on resolution 2024 to adopt standards and criteria and policy. And will our city manager read that ordinance for us?
Our first item of business is resolution 2024-06. There's a copy of it in the packet. Essentially, this is a requirement that there be a publicly adopted criteria and standards as it relates to your chief executive officer position prior to interviewing, prior to going into executive session to discuss. And so what this resolution does is publicly state what our hiring standards will be, what our criteria will be, and what our policy directives will be in this process of selecting a new chief executive officer for the city. Resolution 2024-06, a resolution adopting hiring standards, criteria, and policy directives for the purpose of hiring an interim city recorder manager. Whereas the City of Lakeside City Council would like to employ an interim city recorder manager, and whereas hiring standards, criteria, and policy directives are critical to be transparent as to the employment of said position, including allowing and welcoming citizen input in their determination, and whereas the city has recently adopted said hiring criteria and policies in November of 2023, but still wants to allow updates, modifications, and citizen consideration for the projected employment of a new interim executive officer. And whereas the attached job description and advertisement will be used as criteria for evaluating candidates for employment, now therefore be it resolved that the Lakeside City Council formally adopts the attached exhibits: Exhibit A, hiring standards; Exhibit B, criteria; and Exhibit C, policy directives. And this is prepared for adoption. There is a modified copy with the council president's signature rather than the mayor's sitting over there, should this get adopted this evening. So the first item of business is a public hearing regarding this document, allowing public comment prior to the council considering the resolution. Oh, I should read the Exhibit A, hiring standards. Experience working with the public, experience providing proficient customer service, ability to effectively communicate both written and verbal, ability to reason and resolve challenges and situations, ability to effectively supervise and review works of others. Exhibit B, criteria: experience with money management, including multi-fund budgets, experience in creating and presenting reports, knowledge of the principles and practices of public budgeting, public finance, and personnel management, ability to analyze complex problems and conduct necessary research to solving them, ability to staff city council, planning commission, and committees as tasked by the city council. Exhibit C, policy directives: increase the transparency of the decision-making processes for the city of Lakeside, increase the communications on behalf of the municipal organization, keep the wastewater treatment plant project timeline, support the efforts of consistency and code enforcement, provide proficient customer service, treasure, honor, and respect your role as a staff for the city council, planning commission, and committees assigned to you. At this time, we should conduct a public hearing regarding just this resolution, allowing for public input for this draft document.
So. Public input. You have anything to say? Public input.
Thank you for asking. Let me see if anybody has a hand raised.
James, like,
I have nobody raising their hand here.
We have, Mayor Edwards that would like to speak.
Was wondering if the word increase should not be changed to ensure. Rather.
Is that in reference to the communications?
And
That would be up to the council to consider.
Anyone else? All right. One with public input then, and, see, what else do we have to do on that? And we have to be up for the first hearing.
You need to adopt the resolution either now or after the public hearing for the ordinance.
So, we can adopt this, resolution. We can motion.
I move that we adopt resolution 2024-06 as read.
second,
Any discussion?
I would like to say something. To, Mr. Mayor Edwards' point. What do you guys think? I mean, I think ensure or increase are both fine.
I'd like to do both.
Yeah,
Ensure and increase, you're saying that?
Well, either one or both, but. That would be fine.
I'm fine with this one.
so can we still adopt it while saying there's that modification
We
tonight?
can adopt it with that change.
Okay. Yeah, I would like to make that change.
All right, would you restate the motion with that change? Or, disagreement, that's
I move that we adopt resolution 2024-06 as read, but considering the change that Counselor Wood proposed.
Okay. Been moved and seconded, and any further discussion? All right, we'll vote on that. Hold it for him and say aye. If you approve.
Aye.
Hold it for him and say nay if you don't. All right, passed. Resolution will be adopted.
We'll have to sign it at a later time after I modify it.
Okay, now we have a public hearing on ordinance 2401. And this is ordinance amending the previous ordinance and changing some of the language and our ordinance code. So we will miss it.
Presiding officer, this is on your agenda this evening, mostly for two reasons. One, it was planned to seriously consider this at your June 13th meeting, and your June 13th meeting is already very, very full. And so it was decided that it would be more appropriate to have the public hearing for it tonight and maybe a final version agreed upon tonight and then adopted on June 13th. And the second reason is that this particular issue of code enforcement is significant enough in this community that I think the mayor and the council came to a consensus that we needed to allow the public to have a clear and more or less a single focus gathering this evening in order to provide input on what will be a very significant change in how we do code enforcement in the future of our community if the ordinance is adopted. So before you this evening is a public hearing on this ordinance with the intent that the council later on will wordsmith it as they wish to have it presented to them for adoption on June 13th, after hearing input from the community. Now, there are a lot of elements to this proposed ordinance as it relates to the repeal and the act and definitions. I would suggest that the most significant is the process of enforcement, which is employing an independent public hearings officer for the determination rather than the court system, which the city set up on paper a number of years ago, but has never realized in actuality a municipal court. So before the council tonight, staff is asking council to listen to the public, change this draft ordinance as you deem appropriate, and then direct staff as to what you want to see presented for your potential adoption on the 13th of June. Any questions about process or where we're at here? So I would suggest you allow public comment on this draft ordinance, and then afterwards direct staff as to changes as you deem appropriate that you wish to see for consideration at your next regular council meeting.
All right, public comment. Ready to come up? You should, but I would come up. Talk at the podium. Michael Armstrong, Lakeside 415 Park Avenue. I submitted a written report and observations. I don't know if y'all were able to see that. Did you do it? Yes. I really do encourage that you consider either going with the city reporter manager, being the person that determines whether or not a nuisance exists, or the hearings officer. I think it's getting real complicated when you rewrite and amend the abatement process. I mean, I wasn't even aware this was going to be discussed tonight because it didn't open on the city website. So I wasn't aware that you were going to talk about it. I would give it real hard consideration and consider going back to the way it was. And there were 5 cases, like I pointed out, that were successful when the city prosecuted with the city attorney. Anyone else? Or anyone on Zoom?
I have another question on this. On page 2, it says persons in charge of the property. And if I'm not reading this, it says.
Excuse me. Could we request people to identify themselves when they rise to speak at the podium, Mr. Chair?
I just have a question. Page 2. It says persons responsible. But right above it says persons in charge of property and agent, occupant, lease, tenant, stuff. And it says persons responsible. Is that for abating a nuisance, meaning any and all, or should it be any or all? Because you're saying like an agent, like if E&L Edwards is renting a property for a landlord, you're saying E&L Edwards is responsible? Or to proceed, you're going to have all of the following? That's, I just wanted to make sure. Am
I read that as, I thought it was just a definition of,
But it says the person responsible for abating a nuisance means any and all of the following. A, the owner of the property or a building or property where a violation failed to comply has occurred. B, the person in charge of. So right above it says person in charge of the property, an agent, occupant, lease, tenant, contract, first or two. So an agent, everything would be I'm just saying, property management companies. So are they going to be responsible?
you're asking if it means one or all of those, A, B, and C.
Yes, any or all of them. Because you're saying any and, that means and all of them have to be, I don't know. I just thought about that. Yes,
Yes, sir.
Laura Valenci's, Railroad Avenue, Lakeside. It would be nice if, I don't know if it's possible for you to say, okay, I have nothing written, so I'm just pulling this out of my head. You are required to post in the post office, McKay's, and where, right here in front of City Hall. We've had Wi-Fi, we've had internet for 2 decades now. Is there any way that you can change an ordinance that says that you need to have this available for your citizens online? Because this was not pull-upable. So in order to have an effective discussion with your citizens, we need to have information before the meeting, more than 10 minutes before.
It was on the website, it works for me, I don't.
It didn't work.
I printed off it. It was where I kept the current copy and that's where I printed and accessed on the city website.
Can I just stay on the side of the website? We've had an upgrade in the system, and they have been having some problems, and they've been doing a lot of back and forth to the company that wrote it, so there might have been times, and there's been times when I couldn't get on the site. So that might have been what you were seeing, but it is on, and it was on there quite early.
Well, 3 people at least experienced it spending. So it's just a good discussion for disclosure in order for your citizens to respond effectively.
We do what we can, if it doesn't work, I don't know, it doesn't work, we had nothing we can do about it. Okay, anyone else?
David Smith, Lakeside resident, under nuisance, number B, offends decency. I think you're stepping on the Second Amendment there. Private property and under D, unlawful interference with obstructs or tends to obstruct or render dangerous for passage any public or private. City does not have jurisdiction over private property for a public right of way. You might want to look at plainly audible sounds. Public place, there's another private owned property there, sound production device. Just, non-encumbrant nuisance, you might want to look at as well. That's on page 4. Page 3 is the sound producing devices, public places, and plainly audible sound. You might want to look at the wording and see about correcting some of that.
Question, David.
Yes, ma'am.
On the sound producing device, which one do you?
Pretty much you're saying if I'm playing my car, I'm driving down with music in my car, it's gonna bug you for 10 seconds, what are you gonna do? Call the complaint officer and say, hey, I need to get me a ticket because my music was too loud in my car. And come 5 o'clock, you guys really need to think about this. Who's gonna enforce the code when he's off Friday night till Monday? I think this needs to be, let's go F. Under nuisance, essentially interferes with the comfortable enjoyment of life. and property, or tends to depreciate the value of the property. Well, I think you want to leave out with the comfortable enjoyment of life. Who's to say one enjoyment isn't someone else's? Just because you don't enjoy something doesn't mean someone else does. Kind of like offends decency. If I have a Go Brandon flag in my yard and it offends, say, Randy Thomas, well, doesn't offend me. So you need to really look at how you're writing your nuisance ordinance here. Thanks.
Anyone else? No.
My name is Randy Thomas. I'm a proud resident of the wonderful city of Lakeside. And I just was having comments on the situation that we have. The fact that we're at this stage, this step, compared to nothing that we've not done in the past. So I'm seeing that we're looking at dots and little thous and these type things, and they are probably good to correct those. But if we looked at the big picture of what this is all about, is that we've made the step forward to address these issues without being put down on future meetings. We only have X amount of meetings per year. And I know that announcements and alerts of how we should deal with these things are good, but the very fact that we're having this type of discussion creates this feeling of who is what and who's not going to get things, and my idea of the bad is someone else's not. But it's basically our whole purpose of this city is in our groups, whether I'm on the planning commission or you all are on the city council, is what is good for the public and all. How does it affect everybody? What are the decisions that we make going to affect the person next door? If we are going to maintain those kinds of relationships, we need to make serious thoughts about what we have to sacrifice to get that, and what pride that we have to put under our bed or whatever in order to achieve what we want to do here. And so when I see this new part, the new idea here going on, I don't want to feel like we're all being discouraged about pursuing it. But at the same token, be forthright and powerful enough to make sure we make a decision that is for the well-being and good for everyone. Thank you.
All right. No one on Zoom?
No, I just checked.
All right, close the public input. And I guess now we will review the draft document and see what we'd like to change or what we want to do on it. And this, like all ordinances, will go past our city attorney for review and.
This was written by the city attorney, and it is ready to go unless you make significant changes as it relates to the law, I guess I would say. Not if you make significant changes to particular words, most likely, but unless there's some intent change, this is ready, has already gone through legal review.
I have anything to.
Before I make comments on my own observations on the draft, I'd like to briefly respond to a couple of people who made comments. Ms. Armstrong and Mr. Smith. They were commenting on definitions within the ordinance, and I just want to observe that the portions of the draft in front of us that they had concerns about are not new. They're already existing in the current code and have been for years. When there's an amendment to the municipal code, it has to be done by what's called repeal and replace. So you have to expunge the entire section that you're amending and replace it with a new version. And the draft that we have in front of us isn't what's called a markup copy. It doesn't show what's been changed. And the portions that were raised as potentially problematic are, as I said, pre-existing. They're already in the code today. Having said that, the first item I noticed, starting at the top, is the title. The title ends with, "and amending ordinance 95-194. And there's actually no content in this draft that amends ordinance 95-194.
You probably, you are most likely correct. This amendment, this ordinance this revision got separated because we took out the land use, and I'm assuming 95-104 involved land use.
194 is division of land.
Yeah. So we should end with a period after 295.
Yes, period after 295.
To the audience, when we started working on this project, we learned that we had to separate out what involved land use and what did not involve land use, because we could not change our code enforcement processes involving land use without first notifying the state and giving them 35 days to comment. So what we're doing tonight and June 13th is hopefully affecting code enforcement for non-land use items. Meanwhile, this same process is going to get repeated in July regarding land use items. And what Councilor Ward was so kind to just share was that we needed to change the title as well, since we took out the land use stuff. Thank you.
My next comment is sections 4 and 5 of the draft. Section 4 reads that section 93.07 the Lakeside Municipal Code shall be repealed. That's fair enough. And then section 5 says section 93.08 of the Lakeside Municipal Code is repealed and replaced with the following. And then the text that follows is numbered as 93.07. It's very confusing to structure it this way. It should just be a straight repeal and replace of 93.07. And I'm raising this, it's not a mere technicality, it creates confusion further on that you'll see.
So would you be kind enough to provide the page number and what language it is you would like to see changed?
Page 4,
Okay,
it's section 4 of the ordinance.
got it.
I'm suggesting that section 4 should be omitted.
Okay,
And section 5 should be amended to read section 93.07.
got it.
Repeal and replace.
I'll run by legal counsel, but what you'll see on the 13th, most likely we'll see that change if that's what the council agrees. Okay. Next.
All right, within the proposed revision to 93.07, 93.07B sub 3 reads a description of the nuisance and the property condition that violates applicable code sections. And I'm wondering if it should be nuisance and the property condition or nuisance and or the property condition. Because you can have a violation as both or just one or the other.
I'm sorry, what section is that?
Section 3.
It's in section 5 of the ordinance.
Yeah.
It's the text for 93.07.
Yeah.
It's subsection B3.
Got it.
You're suggesting and or?
Right. Where it says nuisance and the property condition, I'm suggesting and or. Not a big deal. But if you don't like it.
Makes sense to me, because you can certainly have a nuisance without a property.
And move to the next one. Okay. Same section B, number 5. Reads a deadline or specific date to correct the order to comply. And the previous or current code says within 10 days after posting and mailing of the notice. And my concern with the deadline or specific date is that it's, from a regulatory perspective, it's arbitrary. And so you're leaving it to your code enforcement to decide how long to give the person. And they may give them something that's unrealistically short or excessively long.
I have a point to bring up with that,
Okay,
because I kind of like that it's up to that person. It gives a little bit of flexibility for the problem. I mean, if you have a sound problem, a barking dog, or your property is completely trashed, might take you longer than 10 days or,
sure.
yeah.
Would you be in agreement with having a minimum length of time? So that someone's not given an unreasonable deadline to come into compliance.
Yeah,
10 days might be that minimum.
That's what's in the current code. I don't know what you like.
I like the idea that there be a minimum, and I like the idea that there's a little bit of judgment applied to each one of those. You know, you might have, like you said, a huge property that it's not gonna get dealt with in 10 days reasonably.
So we stick with the minimum 10 days.
So you might consider rewording this as a deadline or specific date to correct the order to comply, and the penalties that will be accruing on a daily basis if not remediated by that date. Such date being at least 10 days after posting and mailing the notice.
be a minimum of 10 days.
Yes.
Okay.
Jumping ahead to section 6 of the ordinance, which is on page 5. Read section 93.09, the Lakeside Municipal Code shall be repealed and replaced with the following. And then the following is number 93.08.
I'm not seeing the point.
All right.
It's unnecessarily confusing. And on that same page, in the draft replacement for 93.08, if you go to subsection B, it says notice of order of failure to comply shall be served as provided in LNC 93.08.c. And it's actually 93.07.c. Look at subsection C, it says notwithstanding LNC 93.08 above. And the 93.08 is incorrect, it's 93.07.
So you would like to see notice of failure to comply to be 93.07?
No.
What is it that what language are
We
you
have the section in
suggesting?
the draft here entitled 93.08, notice of failure to comply.
Correct.
That's perfectly fine. But it comes right after a recommendation to remove 93.09 and replace it with this version of 93.08.
Correct. Because we're removing 9309 from the old language.
The way this is crafted is creating a lot of confusion.
Okay, so,
Normally you repeal and replace a numbered section with a section with the same number.
okay,
And I'm
So you-
suggesting section 6 should be amended to read section 93.08 of the municipal code is repealed and replaced. Since I just recommended, and you agreed with me, that section 4 on page 4 should be removed, And what's set in section 5 on page 4 should be renumbered as repealing and replacing section 93.07.
Okay, I think I still have the same question though. I hear you asking us to label notice of failure to comply to be 93.09.
No, sir.
That's not what you're asking.
No, sir.
What is it that, just tell me what language you want changed and I will write it down.
Section 6 to read section 93.08 of the Lakeside Municipal Code. Repeal and replace.
I have a question about that. If you're changing the section that's being repealed, what about you repealing a different section? I get you're replacing it
That's my
with,
point. If you're repealing 93.09 and then replacing it with 93.08, that doesn't make any sense.
okay,
Subsection D of the draft of 93.08. At the end of that single sentence, it makes reference to LMC 93.08.c. That has to be changed to 93.07.c. Because that's where the standard being referred to is addressed.
So are you speaking of more than one change here? Or are we still dealing with changing section 6 to read section 93.08?
Section 6, you have a draft of a section that is called 93.08.
Yes,
Notice of failure to comply.
yes.
Subsection B of draft 93.08, which is a single sentence.
Yep.
That single sentence ends with the number 93.08.c.
Yes,
That number must be 93.07.c.
okay. Got it.
In subsection C starts with notwithstanding LMC 93.08 above. 93.08 needs to be 93.07.
Got it. Next,
Page 6. And there's a bottom, there's a subsection I.
Yep.
That reads, a tape recording shall be made of the hearing, which tape shall be retained for at least 90 days following the hearing official's final judgment.
Mhm.
And we had agreed at our last discussion on this that the 90 days should be 1 year in case evidence is required for a hearing in court. On page 7. Page 7 represents the beginning of a draft for a repeal and replace of section 93.10. But there's no title to this draft section. So there needs to be a title, which I believe should be section 93.10, abatement by the city. Above the sentence, the person responsible is not abated the nuisance, etc. The section title is missing. Code section, not the ordinance section.
I'm not seeing the 9310. What paragraph are you
That's
talking about?
the point, there isn't. So if you look at the bottom of page 6. Yes, the ordinance section 8.
Yep.
It means section 93.10 of the Lakeside Municipal Code shall be repealed and replaced with the following. Turn the page, and there's the following. And the following has no title and has no municipal code section number.
Okay,
And I'd like, lastly, I'd like to go to page 8. The top of page 8 sets out the monetary penalty to be assessed.
yes,
Above shall be determined in accordance with the following formulas described herein. And it's pretty simple, but what's missing here is it says that what the fine is per day, but it doesn't establish what the first day of accrual of fines is. And what I'm getting at here is, let's suppose someone receives a notice to comply. Do fines start the day the notice to comply was written, even though they have not yet had a chance to comply yet? And then suppose that they have some valid objection to the notice and they ask for an appeal. The hearings officer has up to 45 days to hear their appeal. And this person effectively could be fined for every day they're waiting to have their appeal heard.
And another 15 days after that, that they have to make a decision.
and decision time.
Right, so I'm suggesting that the ordinance should be amended, or the code draft should be amended to establish the first day that fines accrue. And I'm suggesting that it should be either the date of the service of notice of failure to comply if there's no appeal requested, and otherwise it's the date of issuance of determination by the hearings officer. So if a person gets their failure to comply notice and they don't comply and they don't ask for an appeal, then fines start accruing when that notice was served. If they go through the appeals process, they're not being fined until after the appeals or the hearings officer has heard their case and has issued their decision.
Agreed.
Agree.
Okay,
I don't have anything else.
Sure. All right, anyone else?
I had a couple things I noticed. On page 5, under notice of failure to comply, B, looks like we just repeat the word notice twice there.
Yeah, I saw that. Notice,
The
notice.
first occurrence is a title. The title of the subsection tells you what that sentence is about. I know it's weird, but
Okay.
Oh, I got it.
In the previous section, though, it's underlined. Like notice was underlined,
Right.
maybe to, for consistency
Right.
purposes, that could be.
that should be too.
I apologize, I had one other thing I wanted to bring up. Oh, on page 6, it just seemed to me that using the language tape recording was out of date, and maybe we could just remove the word tape and a recording shall be made of the hearing.
I thought we talked about that earlier.
Oh, we mentioned that previously as well.
Should it be digital?
Or just a recording.
I just,
It doesn't have to be digital, doesn't have to be.
So,
yeah, I think just removing the word tape.
Yes.
And then just otherwise, I agree with most of the points that counselor before me made. Those fines could stack up for months before it's even really determined on whether or not a person is in violation. So I agree with all that stuff.
Anyone else?
I do have a question about under nuisance, to David's point, where it says, you know, unlawfully interferes with, obstructs, or tends to obstruct or render dangerous for passage on any public or private street. What is the legal jurisdiction do we have if there's a nuisance on a private street?
What page are you on?
To
Page 2.
under nuisance, section D.
Now, are you talking about two different individuals on a private street? Is that what you're talking?
No, more like if there's a nuisance, let's say someone has a big motorhome parked, blocking part of a private street. What jurisdiction would the city have to go and abate that or?
Or library bushes grow into the street, that wouldn't be city's business, it's some private property.
I think,
Well, we disallow abandoned vehicles on private property. We disallow, you know, people living in RVs on private property. So
Well, this is
What-
private street.
you might not be thinking about a private street correctly. In most instances, a private street is a recorded easement of way, but it hasn't been dedicated as public property. So technically, it's privately owned, but the owner of the property doesn't have any rights to develop over that easement, and they don't have any rights to determine who can or can't cross over that road. And in our community, there are a number of private roads where a blockage would create safety issues for individuals who live in neighborhoods that are serviced by those private roads.
Ambulance, fire, police.
Exactly, yeah, okay.
So you good with that? Or-
I'm good with that, yeah. I mean, we could argue about the point of offense decency. I mean, I think there's a bare minimum line of decency that most people know, but that's probably a pretty common term for code.
That is a point that I brought up previously at a meeting that I didn't like because for the exact point that David made, that it just leaves that up to a huge judgment call. And what is decent or offensive to one person doesn't necessarily always fit. So we do have to be careful where we're going there.
Yes, we're gonna be stepping on somebody's rights.
That's what I'm saying. David has the right to be offensive in many cases.
Thank God.
It's just like, what is the debt? How are we defining debt? We have lots of definitions here that we've been discussing, but we don't define decency, to my knowledge.
What
So
would
then
you,
that's left to someone's judgment.
what would you suggest for,
I don't know that maybe B just goes away. Unless there's
Google,
other
is there a Google definition for decency? You can just add after it to. I mean, I don't know what the,
That's been fought over in the courts forever.
yeah,
Nothing's ever been able to be completely decided. You're right, the person's business is not the other person's business. How do you decide? That's right.
but is it a decency against the law? Is it something that somebody's out there that's basically, you know, is it right? Is it wrong compared to the law?
Well, it's fairly allowed by the law or not allowed by the right or wrong, or, you know, opinion. Most communities have some sense of a standard for decency that is usually not a law written, so you will do this, you will do that. Maybe things like public urination or something like that, you can say you can't do those, but as far as playing something too loud or being your house of weird color.
Or expressing a political opinion like you mentioned, you know what I mean? It's. We have a couple in the audience that might have.
Well,
some
it's up to the chair to decide.
Does the council wish to take comments on this?
Yes.
All right, let's do that. All right, who is?
Can I just do it from here, please? Karen Crouch, Lakeside. I would like a definition of decency to add that we won't be putting expletives on our property that children can see. We've had people do that in the past with, and they might say it's their First Amendment right, but you know, who has the right to expose children to that type of thing?
I was just.
Just really quickly, Councilor Wood's section on the right of way, that's where it would be found in the code of ordinances under right of way. I think it's 94, section 94, and in street, section 95. So it would have been beneficial if you all had a copy of that code, and then you could compare what's existing and what's being replaced.
Anyone else?
The point Karen made, I agree with your point, but I think that can get very dicey legally. That's, like you said, encroaching on people's free speech thing, so I'd be hesitant to do something like that. Personally, but maybe legally we can look into something.
Okay, anyone else? Anything else? Do we have enough to ask our city manager to spend a few minutes rewriting this?
We have one more hand up.
Right here.
Lynn?
Elaine Gunshot, I have a question on what Rob was saying to begin with, when you said on page 4. At the very end of what you're saying, I heard you say that the days you give is from the date of notice, mail, you said the mailing of the notice. Is that correct? Yes. Because then it says here on C on notice that it's going to be by registered or certified mail. And it's going to be to the property owner at the address. So they're going to go out and post at the residence. But you're also going to send a letter to the property owner, and what if they live in Florida? And you said if I certified mail, it takes that long to get to them. So I think because of the mail system now, and I know our ballots, besides getting lost, they say you allow 7 days, and they mean 7 days now to get back. And then on the next page, you said a notice of failure to comply may be appealed within 10 days after its mailing. I just think that if they're out of state or banned or something, are you giving them enough time for registered or certified? Because certified you have to go and sign for. So if you go home after work, that means you're going to come back. You could be out of your time.
They don't do these mailings like standard mail or certified mail, they do both.
Okay, it says here that notice. It says, city administrator shall cause a copy of the order to be forwarded by registered or certified mail, postage prepaid to the property owner at the address shown on the current Coos County assessment record. That's not regular postage, that's registered or certified. That's different than just sending it regular mail.
You're surprised. I stand corrected, sit corrected, actually. Yeah, I'm describing what we've been doing for when I was on staff, but you're correct.
And like I said, you have to, it's different even in Lakeside. I mean, I could see that, but when you're sending it to the owner, I just think you should look at more time and figure out what you do for them.
I think you made a pretty good point there, that mailing time could be 2 days or 8 days, 10 days.
Yeah, I can do it again. If something to consider is you're sending it by register or certified, that I think needs to stand because that's your only proof. But if you post it and let's say you send it, I think it should be 10 days after the notice been received. Because it may take 7 days to get to me, but then I have to maybe appeal after it's mailed. You're not saying a phone call, you're not saying written. So you have to give time. And if you say, if I say that I signed it, you instantly get notification that if I signed for it, my 10 days start then.
I appreciate the if you sign for it. There are a number of people who will simply refuse to sign for
But then there's the
anything.
thing in your thing that says, if it's, attempted, refused, it's sent back and says refused, your 10 days would start from then, refused. Because yeah, if you refuse to sign it, then they mark it refused and send it back.
If your mail carrier leaves you the notice that says you have a certified item, you just never go to claim it. You haven't technically refused.
But then they don't hold on to it for so long, they send it back.
Right.
So then you would have, it was returned.
In theory, they send it back.
How about just some language that says the clock doesn't start counting for 7 or 10 days, like she mentioned, that happens with ballot.
I just think that, like I said, I know what would happen if, I had property and then I live in your rent, besides putting the agent and everybody you're doing. I just know where I worked before, we started from the date they got it, or if it came back, then we would log it as coming back and then it started.
I'd like to allow some time for mailing at least. I don't know how many days or how we define it, but you have to realize that it can take a week or more for someone to even know that they get it.
Everything most of it should really slow down too. They're taking a little longer now.
And also you have, like, depends on when it was put in mail, our mail goes out early. So let's say they take it down to the mail, you lost. I think it's not what it used to be. We used to figure 3 days, then within 5. And now, when we didn't get our ballot, she said, well, give us 7 days.
Well, it very well may be legal standards specify how long you have to give from when you send something like this. Mr. Thomas.
Yeah, Randy Thomas. Isn't it just possible that when I get bills and due bills, and I have properties down in California where I sent, quite a few things back and forth. And it takes at least 72 hours. I have a family in Florida and it takes 48 hours. And the amount of people that we really truly have that's out of state in this area, can we count them as, are they 25 people? Is it just half a dozen people that have this issue? Does our ordinance, again, I know we need to be specific on certain things, but it's confusing on the fact that about most of the general population that have homes and are running their homes like this are here. And that the people that we send to might not be necessary to dwell on isms and things of this words here. I was also thinking about the forget it.
Anything else? sounds like we need to rewrite part of this and maybe spend some more time in the meeting. Day or nay.
Well, how many of us agree that there should be some allowance for time? Can we just give the city manager a number and have him apply that and we can approve it next time, or?
We can do that.
About 14 days. 14 days.
That's more than I was thinking, but 7 to
15.
10 was what I had in my mind.
We're already at 10 and we think we need more than 10. Correct?
Mhm. That's what
The
I
way it
read.
states now is 10 days.
Mhm.
And we're thinking we need more, so that's 14, or is it 10 days from the date that it's received and received or returned?
Well, if we went with Nikki's suggestion of 14, we can just say maybe it takes 7 days to get there and then they get 7 days, I think that's, I guess, is pretty reasonable then.
So,
You can't expect it to take more than a week in most places,
so 14 days over to 10 days? Is that what you're
14
saying?
days past mailing.
We talking about the 10 days that are on page 6?
Yes.
We're talking about,
Yes.
I believe so. Thank you.
just to put it in context a little bit, that 10 days is after notice of failure to comply has been sent. So, if I'm recalling from this, first they get an order to comply,
Mhm.
and then after some time, they get a second notice, which is notice of failure to comply. This is basically the second notice.
I think they need 2 weeks. This, 14 days is,
Whether it's the second or 10th notice, you still have to give them the opportunity to receive and reply.
like 14.
I would support that.
Oh, that's fine.
I have one more question.
Can I get conclusion on this one first, Counselor? So on page 6, you want the 10 changed to 14? Is that the consensus of the council?
Section 9.09 sub A,
Section 309, what?
sub A.
Thank you, Counselor Wood.
To Elaine's point about the person responsible. So we're saying that the person responsible for abating a nuisance means any and all of the following. So it could be the person renting, the person owning, and the property management company. They're all responsible, say, in a situation like that.
One can't say, the owner can't say that's the property manager's problem.
And the property manager can't say it's the tenant's problem.
Exactly.
Well, actually, if you're looking at the definition of person responsible, and then you look at B, it says the person in charge of the building.
Mhm.
And then you have to go up to the definition of person in charge of the property to see what that means. And it lists out agent, occupant, leasing, tenant, contract, purchaser, or other person, and then says having possession or control of property or supervision of a construction project. So if somebody's renting a property and they also have a property manager, the property manager is not the person in charge, it's the tenant, they're the one in possession and control. It's not just being one of those people, you also have to meet that condition of having possession or control.
Okay. Got it. I'm confused about the supervision of a construction project. So like if someone was doing a house demo and it was annoying someone else, that would be a nuisance violation. Noise or,
It's ordinary and customary. It's
Okay,
ordinary and
okay.
customary to take something down, to take it down and have it last 3 months. would be different.
okay, so
Right.
it's like an ongoing. Got it. Yeah, that was just. Got it. Okay.
Okay. So, I don't know.
Nope.
All right.
I, on this, if I may, the subject is on C on page 5, where we're talking about the notice. If I'm reading this right, it says, if not the property owner by personal service, regular and certified mail, that's what you must have been talking about, it's just postage, but certified mail, return receipt requested, or the responsible person cannot be located by posting. So we're on to that time frame again. Who's going to do the personal service? The sheriff's department, are we gonna ask them to do it? Because, I mean, you're saying at the address shown on the current Coos County assessment records and on the responsible person, if not the property owner, by personal service, regular or certified mail, and regular and certified.
It can be one, they got courier service instead of personal service.
Well, personal service means they go out, serve the person, file a return. You're talking personal service normally. So, like I said, it's something to think about once again. So you're making this notice thing by certified mail, registered mail, and then if it's not this, and it's a responsible person, if not the property owner, personal service.
Are you ready to move on? Okay, unless there's something else on the, I think Councilor Wood wanted to make a brief announcement before we move into exec session.
Oh, yeah, I just wanted to let everyone know, tomorrow's exciting because we have a field representative for Congresswoman Val Hoyle coming out to Lakeside. And many other people from the Regional Solutions team. We got DEQ, ODFW, CCD. There's a bunch of really important people coming to Lakeside to see what they can do to help us out in any and all aspects of things. So we're taking them on a tour of the wastewater plant, having lunch at the lodge. So really excited to show them Lakeside and show them what we have to offer, and hopefully they can point us in a direction for.
Are you gonna show them all of the druggies and
Our intention is to show them the problems that we have in Lakeside, like things like that. I mean, it's hard to not see those things when you're driving to,
very?
yeah, so, yeah. We're covering all the bases tomorrow, so.
And what time is that? With the showing.
Well, we're starting lunch around 11, and then continuing from there, so. All right, that's it.
All right. We are now going into executive session for Oregon Revised Statutes 192.660, sub 2, sub A. So the governing body can deliberate on who may hold, we may hold an executive session to consider employment of a public officer. So at this point, we need everyone to leave.